You don't need a mansion or a Hollywood name to leave behind a story that's more than just fame.
Me to need a will, just a family, or a cat plotting world domination. Welcome to Celebrity Estate Chaos, where we prove a lot of things. Like how estate chaos isn't just for millionaires with private islands, anyone with stuff, relatives, or that one weird collection you think nobody's fighting over. And chances are, they will. Anyone with...
Welcome to the Deep Dive. Today, we are grabbing one of the most unbelievable, just sensational celebrity court sagas of the last 30 years, the estate war surrounding Anna Nicole Smith. And we're doing a kind of forensic analysis because, look, what seems like simple tabloid fodder is actually, well, it's a definitive masterclass in how not to do estate planning, a multi-decade failure. Our mission today isn't really about the gossip. It's about extracting the valuable, the real-world inheritance lessons. Because this story, it started with, the headlines, 26-year-old bombshell bride, an 89-year-old oil billionaire, J. Howard Marshall. But it spiraled into just absolute legal chaos. And you don't need to be a billionaire to create these billion-dollar type legal problems, this story. It's a critical reality check, especially if you've got a blended household or maybe some complex family dynamics.
Yeah, what's so fascinating, I think, is that the core conflict wasn't, criminal stuff or a stolen fortune. Not really. It was a failure of documentation. Just so complete that the fight over what one man intended went all the way to the U.S. Supreme Court.
Not once, but twice.
Twice. It boiled down to a battle over a simple, apparently undocumented verbal promise versus, an ironclad missing paper trail. This whole thing is probably the most expensive cautionary tale in American legal history. Seriously.
Okay, let's set the stage a bit, just briefly. Before the fame, Anna Nicole Smith was Vicki Lynn Hogan. Texas girl, high school dropout, worked at Dairy Queen, eventually found success, Playboy, Playmate, Guess Jeans model. And then, early 90s, she's working in a Houston strip club, and she meets J. Howard Marshall II. He was notoriously private, nearly 90 years old, an oil tycoon.
One of the wealthiest men in the country, easily. And he was just immediately smitten. They got married in 1994. Huge age gap, obviously. Now, here's the absolute pivot point for our deep dive today. Marshall died only 14 months after their wedding. Just 14 months. And in that incredibly short window, he failed to update his estate documents to include his new wife.
Whoa.
That single omission, that's the spark. That's what ignited this decades-long legal marathon that, it basically outlasted almost everyone involved.
Okay, let's unpack that crucial point. What was the core disaster that really kicked off all the chaos?
Well, Marshall's main will and trust documents. They didn't mention Anna Nicole at all. Not a single cent was explicitly left to her, nothing on paper. But she claimed he had verbally promised her half his fortune. And that fortune was estimated, well over $1 billion.
$500 million based on a promise.
Exactly. And that's where the legal machinery just went into overdrive. Marshall's son, Pierce Marshall, he fought that claim tooth and nail. Yeah. He argued, look, she had already received millions in gifts. She wasn't due some massive inheritance on top of that.
And the resulting battle.
Yeah.
Just how bad did it get?
Oh, it was brutal. Protracted, incredibly expensive. We're talking about a fight that stretched over 2 decades.
2 decades?
Yeah, involved 6 separate courts. And the legal fees. Reports say they topped $50 million.
$50 million just on legal fees. Just take a second on that. That's enough money to fund a small city, right? And it was all just burned up by lawyers arguing about what J. Howard Marshall might have intended. It's insane.
It really is. It highlights the staggering cost of ambiguity, doesn't it?
Mm-hmm.
And the case, it just dragged everywhere. Texas Probate Court, then California Federal Bankruptcy Court.
Because she filed for bankruptcy.
Correct. Then the Ninth Circuit Court of Appeals, then up to the Supreme Court, back down, back up again. It was such a legal quagmire that even when she actually won a huge judgment in $2,474 million.
Wow, a win.
That decision was immediately reversed on appeal. So poof, gone.
And here's the really shocking part, the tragic outcome that I think most people missed amidst all the headlines. Despite all those years of litigation, all those court battles, wins, reversals, Anna Nicole Smith herself, the claimant, she never received a single dime from the Marshall estate, not while she was alive.
$0. That outcome for the original claimant is it's a stark, devastating reminder. It shows that even winning rounds in court means nothing if the fight itself bankrupts you or, in this case, just plain outlasts you.
And the fight didn't even end when she died, did it?
No, not at all. The battle continued in her daughter Danny Lynn's name after Anna Nicole died tragically in 2007. And it went on for years more after that.
So what finally happened? How did it all end?
Well, eventually by 2021, the Supreme Court essentially said no more. They declined to hear the case again, basically closing the door for good on the Smith side, the billion-dollar fortune. It stayed mostly in the Marshall Trust with Marshall's heirs. And Danny Lynn, Anna Nicole's daughter, she inherited mostly, well, public attention and notoriety. Not the wealth her mother had fought for. The family just lost peace, privacy, dignity. Years of their lives, really. All for nothing in the end.
That right there, that's the deep dive. This chaos, it wasn't just some weird billionaire thing. The failure points are universal, and they hold really valuable, critical takeaways for you listening right now, especially if you have aging parents or blended families or maybe loved ones who depend on you financially. So let's distill this. What are the 5 critical, maybe lesser-known lessons that can help prevent your own family drama?
Okay, lesson number 1. This is the absolute foundation of the entire Marshall Smith mess. Promises aren't binding paper is full stop. The courts are incredibly clear on this. Verbal assurances, things like, oh, don't worry, I'll make sure you're taken care of, or, you'll get the house someday. They mean essentially nothing in probate court. Zip, only a legally executed will or a properly notarized and witnessed trust or some kind of formal contract actually holds little weight. Emails, texts, nope, usually don't cut it either.
But hang on, why are courts so rigid about that? Can't a judge just look at the situation, the relationship, and use some common sense? Apply what seems fair.
You'd think so sometimes, but it's primarily about preventing fraud and maintaining predictability. The legal standard of evidence needed to prove an oral promise, or even like a handwritten note that wasn't properly witnessed. It's extremely high, for good reason, usually. If Marshall had just scribbled down, I want Anna Nicole to have half my estate and signed it properly according to Texas law, maybe, but just someone remembering a conversation. Especially when the existing legal documents say something totally different and the primary heirs are fighting it. It's just not reliable enough for the courts. You absolutely must formalize your intentions using the specific legal documents your state requires. No amount of love or good intention gets around that legal hurdle.
That's a tough but crucial point. Okay, lesson 2 builds right on that. Don't rely on common sense or intent. Courts follow the documents, period, regardless of family feelings or what seems obvious.
Absolutely right. When Marshall didn't update his will after marrying Anna Nicole, the default state laws just took over. Intestacy laws, or the existing trust language, and those default laws. They typically prioritize biological or legally adopted children, in this case, Pierce Marshall. They often completely cut out new spouses, stepchildren, partners, caregivers, anyone not explicitly named. So it wasn't about how much Marshall might have loved Anna Nicole in his heart. It was about how much he legally defined that love in a binding document. If you want someone specific to inherit a partner, a stepchild, a friend, a caregiver, you've got to spell it out explicitly.
Right. If the documents are silent or missing, the state basically writes your will for you. And the state, well, it doesn't know you or care about your specific wishes. Okay, that brings us neatly to lesson 3. Your executor needs a backup. And this is key, neutrality.
As we saw here, these estate battles can drag on for years. Executors aren't immortal. They die, they retire, they get sick, or, critically, they just lose the capacity to handle the immense stress, the financial side, the legal pressures. Yeah. It's a huge job. And if you haven't named at least one, preferably 2, successive backup executors, the court just steps in and appoints a stranger, which adds incredible expense and, of course, zero personal familiarity with your family or wishes.
And let's talk about that neutrality piece, because that feels really critical for listeners, especially in blended family situations. If your family already has some tension, maybe some difficult dynamics, choosing one child as the executor, especially if that child benefits differently than the others. I mean, you're basically just crowning a gladiator, aren't you? You're guaranteeing a fight.
You really are. You're setting them up for conflict, for resentment, suspicion, maybe even lawsuits accusing them of bias or self-dealing. It happens all the time. If we connect this back, in a high-tension family, maybe the single most valuable decision you can make is choosing a neutral executor, an objective third party.
Like who?
A professional.
Yeah, exactly. Professional fiduciary, a trust company, maybe an estate attorney. Yes, they charge a fee for their services, but think about what that fee buys you. It buys impartiality, legal expertise, professional administration, and maybe most importantly, it can buy family peace. The cost of that professional is almost always exponentially less than the cost of family members fighting each other in court for a decade.
That's a really good perspective. Paying for peace. Okay, lesson 4. This uses Danny Lynn's situation as a stark teaching moment. Guardianships and trusts for dependents matter. Immensely. Daniel was only 5 months old when Anna Nicole died. Without clear, solid instructions already in place, boom, she instantly became a legal pawn and, sadly, a tabloid target. And this applies far beyond celebrity kids, obviously. If you have minor children, or maybe disabled relatives you support, or even elderly parents you're responsible for, you need to have continuity of care and funding, clearly outlined, legally outlined. For minor kids, guardianship instructions in your will are absolutely non-negotiable. You have to name who you want to raise them. For relatives with disabilities, you really need to look at tools like special needs trusts. Very important.
Can you explain briefly how a special needs trust works? Because that sounds like a really high-value piece of info for people.
Sure. So a standard inheritance, like just leaving cash directly to someone with a disability, can be a disaster. It can actually disqualify them from essential government benefits they rely on, like Medicaid or Supplemental Security Income, SSI. Their assets become too high. A special needs trust avoids that problem. It holds the assets for the beneficiary, but not directly in their name. The trustee manages the money. So the funds in the trust can be used for supplemental things that improve their quality of life. Maybe therapy, travel, special equipment, hobbies, things government benefits don't cover without jeopardizing those crucial baseline benefits. It ensures financial support and protects their eligibility.
That's incredibly useful. Okay, and finally, lesson 5. This loops us right back to the fundamental mistake J. Howard Marshall made. Update after major life changes. His documents just never reflected his marriage to Anna Nicole. That single oversight, that failure to update, that was the catalyst. That sparked 2 decades of destruction.
You absolutely have to view major life events as legal triggers. Getting married, getting divorced, birth of a child, death of a beneficiary named in your will, a big financial change, even changes in living status, like moving in with a partner or remarrying. All of those things must immediately trigger a review of your will, your trust, your beneficiary designations. Relying on outdated documents is, as this case just screams from the rooftops, probably the single most common and most destructive estate planning error people make.
So, pulling it all together, what does this mean for you, the listener? You might not have oil wells in Texas, right? But you absolutely have a family structure, relationships, assets, things that can create these exact same kinds of problems if you're not careful. Before we jump to the actionable steps people can take, let's just reflect on that pattern of failure again. What really happens when all 5 of these lessons paper over promises, intent isn't enough, backup executors, protecting dependents, updating documents when they're all ignored?
You lose control completely. If you ignore clear intentions on paper, if you ignore updates, if you ignore neutrality where it's needed, you basically leave behind 3 things: ambiguity, resentment, and a massive administrative headache. Ambiguity, that leads straight to litigation. Resentment, that tears families apart, sometimes permanently. And the administrative headache. That ensures that even the money that is eventually supposed to go to someone gets stuck in court, eaten up by fees, delayed for years. It turns what should be a time of grieving and support into a protracted, ugly financial disaster.
That really is the true tragedy here, isn't it? Okay, so we want to give you some concrete, actionable steps you can take right now to avoid your own potential future estate drama. We've established you need a will or a trust, but let's get practical about implementing that.
Right. And one really high-value tip that came through in looking at cases like this is this. Seriously, consider creating a living trust rather than relying only on a basic will, especially if your family situation or your assets are even a little bit complicated.
Okay, explain that. Why a trust over a will? What's the practical difference for the listener day to day, or rather, after they're gone?
The main differences boil down to privacy and speed. A will, after you pass away, generally has to go through probate court.
Probate, the word everyone dreads.
Exactly. Probate is a public process. The will becomes a public document. Anyone can look it up, see who gets what, raise objections, slow things down. It can be long, expensive, and very public. A living trust, on the other hand, is a private document. Assets that you properly title in the name of the trust during your lifetime. They bypass public probate court entirely when you die. That means faster distribution of assets to your beneficiaries, usually lower overall legal fees, and crucially, family privacy. Nobody gets to see the details unless they are a beneficiary or trustee.
That privacy aspect seems huge, especially with blended families, or maybe if you're leaving assets in unequal shares.
Invaluable.
Yeah.
It protects against disgruntled family members or even outsiders challenging the distribution publicly and dragging everything through the mud.
Okay, excellent point. So let's summarize those immediate actions for everyone listening. First, create or update your will and your trust now. And seriously, consider prioritizing that living trust. if you have complex affairs or value privacy.
Second, designate a neutral executor if there's any potential for family tension. Yes, it might cost a fee, but like we said, consider it paying for family peace. It's usually worth it.
Third, and this one is so practical but often overlooked, create a comprehensive, organized record, like a binder or a secure digital file.
Yes, this needs to include everything. Lists of all bank accounts, investment accounts, retirement plans, insurance policies, real estate deeds, digital assets, passwords, contact info for advisors, and importantly, your medical directives, living will, power of attorney documents.
What happens if someone doesn't have that binder? Chaos, right?
Total chaos. The heirs, the executor, they spend months, maybe years, just playing detective. Trying to find accounts, track down policies, figure out passwords. They often miss things entirely. Money gets lost to the state as unclaimed property. This simple step, this binder, it saves literally thousands of dollars in professional fees and hundreds of hours of frustration for your grieving family.
So important. Okay, and finally, ensure that continuity of care and funding are clearly outlined for anyone depending on your seniors, disabled relatives, children. Use the right tools, like those special needs trusts we talked about, or clear guardianship nominations.
Look, to Anna Nicole Smith's story, ultimately, it's her family's story of control lost. Every single delay, every assumption made, and yeah, that famous unspoken promise. It cost her family peace, dignity, and years of their lives. And it shows that even billionaires can effectively die broke if their estate gets tangled enough that the legal fees just consume everything. So true. Estate planning, it really isn't about being morbid or thinking about death. It's actually about being incredibly kind. Kind to the people who will have to sort things out after you're gone during what's already the worst time of their lives. It might just be the ultimate act of love, leaving behind clarity instead of chaos. Don't let your legacy, your family's future, be decided by strangers in suits potentially charging $50 million for the privilege. Get your plans, get your paperwork, and get your peace of mind in order now. Because remember, courts don't fix chaos, they just bill you for it.
That's a wrap for today's chaos. If you learned something, laughed a little, or now feel slightly more prepared for life's curveballs, we've done our job. Don't forget to like, share, and subscribe to our channel and follow us on social media. Catch us on Spotify, YouTube, and anywhere podcasts make you rethink your to-do list. Thanks for tuning in. And remember, if it's important and unexpected, we probably cover it. Stay safe, stay curious, and we'll see you next time.